All right, class, let's talk about some key defenses that can make a contract unenforceable. Starting with duress, which comes in two types, physical and economic. Physical duress is exactly what it sounds like. Sign this contract or I'll hurt you. And if someone signs under this kind of threat, the contract is void. It's like the contract never existed. Now let's move on to economic duress. This is when someone uses a wrongful threat and the other person has no reasonable way out. It's not physical, but it still feels like you have to agree. And that kind of pressure makes the contract voidable. You need two things for economic duress. First, you need a wrongful threat, like I won't deliver unless you pay more. And then second, the other person has no reasonable alternative. They tried to find a way out, they couldn't find another supplier, so they ended up just giving in to survive. There is a classic case, Austin v. Laurel Corp, where the supplier refuses to deliver unless paid more. Laurel looked for someone else, they had no luck, and so they ended up signing under pressure. That's economic duress. Now let's move on to unconscionability. There's two kinds, procedural and substantive. With procedural unconscionability, it's about the process of making the contract. Was one party more powerful? Was the other confused or rushed or misled? We can take an example of, let's say, an individual with a limited education that signs a complex contract in a parking lot at 3 a.m. That would be procedural unconscionability. Substantive unconscionability, it's about the actual terms of the contract. So are the terms shockingly unfair? Now, courts don't usually get involved just because it's a bad deal. But if it's oppressive, then that's different. You can check out the case Williams v. Walker Thomas Furniture. Here, Miss Williams paid off most of her furniture. She missed one payment, and the store took everything back. And this was because of a buried clause in the contract. And the court found both procedural and substantive unconscionability. All right, let's move on to ambiguity. This defense comes up when there's a word in the contract that has two reasonable meanings, and each party understood it differently. Now, if neither party knew about the other's meaning, then there's no meeting of the minds, so no contract. Now, this is illustrated in the case Raffles v. Whittle House, where the parties agreed to the delivery of cotton on a ship called Peerless. But it turned out that there were two ships that had that name. One of the ships was sailing in October and the other in December, and each party meant a different ship. So in this case, since both interpretations were reasonable, it was found that there was no contract. Now, lack of capacity. Let's start with infancy. Minors can void most contracts, but there are some exceptions. If it's a contract for necessity like food and clothing and medical care or shelter, those usually cannot be voided. Also, if a minor turns 18 and keeps the contract going, that's ratification and it becomes enforceable. Next, insanity. So if someone doesn't understand what they're doing because of a mental illness, they can void the contract. And finally, intoxication. If you voluntarily get drunk or high, you usually cannot void a contract unless the other party knew and totally took advantage of you. But if you were involuntarily intoxicated, like somebody drugged your drink, and you didn't understand what you were signing, then the contract is voidable. Let's wrap it up with illegality and public policy. If a contract involves illegal activity, it's void. No court will enforce a deal based on something unlawful. And even if it's illegal, a contract can still be void if it goes against public policy. For example, an exculpatory clause that tries to release someone from liability, even for gross negligence or intentional harm. That kind of clause is usually unenforceable. But for ordinary negligence, it might be allowed, depending on the situation. See you next time.